Interim Government 1946. Jawaharlal Nehru, Vice President of the Council, External Affairs and Commonwealth Relations. Second, Sardar Vallabhbhai Patel, Home, Information and Broadcasting. Third, Rajendra Prasad, Food and Agriculture. Fourth, Dr. John Mathai, Industries and Supplies. 5. Jagjeevan Ram, Labor. 6. Sardar Baldev Singh, Defense. 7. C.H. Bhabha, Works, Mines and Power. 8. Liaquat Khan, Finance. 9. Abdur Rab Nishtar, Post and Air. 10. Asaf Ali, Railway and Transport. C. Rajgopalachari, Education and Arts. 12. I. Chundrigar, Commerce. 13. Gaj Nafar Ali Khan, Health. Joginder Nath Mandal, Law. First Cabinet of Free India 1947. Jawaharlal Nehru, Prime Minister, External Affairs and Commonwealth Relations, Scientific Research. Second, Sardar Vallabhbhai Patel, Home, Information, Broadcasting, States. Third, Dr. Rajendra Prasad, Food and Agriculture. Fourth, Maulana Abul Kalam Azad, Education. 5. Dr. John Mathai, Railway and Transport. 6. R.K. Shanmugam Chetty, Finance. 7. Dr. B.R. Ambedkar, Law. 8. Jagjeevan Ram, Labor. 9. Sardar Baldev Singh, Defense. 10. Rajkumari Amrit Kaur, Health. 11. C.H. Bhabha, Commerce. 12. Rafi Ahmad Kidwai, Communication. 13. Dr. Shama Prasad Mukherjee, Industries and Supplies. 14. V.N. Gadgil, Works, Mines and Powers. Article Table 3.1, The Constitution of India at a Glance. Part 1. The Union and its Territory. Article 1 to 4. Second part, Citizenship. Article 5 to 11. Part 3, Fundamental Right. Article 12 to 35. Part 4, Directive Principle of State Policy. Article 36 to 51. Part 4A, Fundamental Duties. Article 51A. Part 5, The Union Government. Article 52 to 151. Chapter 1, The Executive. 52 to 78. Chapter 2, Parliament. 79 to 122. Chapter 3, Legislative Power of President. 123. Chapter 4, The Union Judiciary. 124 to 147. Chapter 5, Comptroller and Auditor General of India. 148 to 151. 6. Part 6, The State Governments. Article 152 to 237. Chapter 1, General. 152. Chapter 2, The Executive. 153 to 167. Chapter 3, The State Legislature. 168 to 212. Chapter 4, Legislative Power of Governor. 213. Chapter 5, The High Courts. 214 to 232. Chapter 6, The Subordinate Courts. 233 to 237 article. Part 7, The State in Part B of the first schedule, deleted. 238 article deleted. Part 8, The Union Territories. Article 239 to 242. Part 9, The Panchayats. Article 243 to 243O. Part 9A, The Municipalities. Article 243P to 243ZG. Part 9B, The Cooperative Societies. Article 243ZS to ZT. Part 10, The Schedule and Tribal Areas. Article 244 to 244A. Part 11, Relations between Union and State. Article 245 to 263. Chapter 1, Legislative Relation. 245 to 255. Chapter 2, Administrative Relations. Article 256 to 263. Part 12, Finance, Property, Contracts and Suits. Article 264 to 300A. Chapter 1, Finance. Article 264 to 291. Chapter 2 Borrowing, Article 292 to 293. Chapter 3 Property, Contracts, Rights, Liabilities, Obligation and Suit, Article 294 to 300. Chapter 4 Right to Property, Article 300A. Part 13 Trade, Commerce, Intercourse within the Territory of India, Article 301 to 307. Part 14 Service under Union and the State, Article 308 to 323. Chapter 1 Services, Article 308 to 314. Chapter 2 Public Service Commission, Article 315 to 323. Part 14A Tribunals, Article 323A to 323B. Part 15 Elections, Article 324 to 329A. Part 16 Special Provision relating to certain classes, Article 300 to 342A. Part 17 Official Languages, 343 to 351A. Chapter 1 Language of the Union, 343 to 344. Chapter 2 Regional Languages, Article 345 to 347. Chapter 3 Language of Supreme Court, High Court and so on, Article 348 to 349. Chapter 4 Special Directives, 350 to 351. Part 18 Emergency Provision, Article 352 to 360. Part 19 Miscellaneous, 361 to 367. Part 20 Amendment of the Constitution, Article 368. Part 21 Temporary, Transitional and Special Provisions, Article 369 to 392. Part 22 Short Title, Commencement, Authoritative Text in Hindi and Repeals, Article 393 to 395. Table 3.2 Important Articles of Constitution at glance. First, Name and Territory of Union. Third, Formation of new state, alteration of areas, boundaries or names of existing states. 13. Laws inconsistent with or in derogation of fundamental right. 14. Equality before law. 16. Equality of opportunity in matters of public employment. 17. Abolition of untouchability. 19. Protection of certain rights regarding freedom of speech, etc. 21. Protection of life and personal liberty. 21A. Right to elementary education. 25. Freedom of conscience and free profession, practice and prorogation of religion. 30. Right of minorities to establish and administer educational institutions. 31C. Saving of laws giving effect to certain directive principles. 32. Remedies for enforcement of fundamental rights including writs. 38. States to secure social order for the promotion of welfare of the people. 40. Organization of village panchayat. 44. Uniform civil code for citizen. 45. Provision for early childhood care and education to children below the age of 6 years. 46. Promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker section. 50. Separation of judiciary from executive. 51. Promotion of internal peace and security. 51A. Fundamental duties. 72. Power of President to grant pardon, etc., to suspend, remit and commute sentence in certain cases. 74. Council of Ministers to aid and advise the President. 78. Duties of Prime Minister as respect the furnishing of information to the President, etc. 110. Definition of money bills. 112. Annual financial statement budget. 123. Power of President to promulgate ordinance during recess of Parliament. 143. Power of President to consult Supreme Court. 155. Appointment of Governor. 161. Power of Governor to grant pardons, etc. and to suspend, remit or commute sentence in certain cases. 163. Council of Ministers to aid and advise the Governor. 167. Duties of Chief Minister with regard to the furnishing of information to Governor, etc. 169. Abolition of or creation of Legislative Council in states. 200. Assent to bills by Governor, including reservation for President. 213. Power of Governor to promulgate ordinances during recess of the state legislature. 226. Power of High Court to issue certain writs. 239A. Special provision with respect to Delhi. 249. Power of Parliament to legislate with respect to matter in state list in the national interest. 262. Adjudication of dispute relating to waters of interstate river or river valleys. 263. Provision with respect to an interstate council. 265. Taxes not to be imposed save by authority of law. 275. Grants from the Union to certain states. 280. Finance Commission. 300. Suits and proceeding. 300A. Person not to be deprived of property save by authority of law. Right to property. 311. Dismissal, removal or reduction in rank of persons employed in civil capacities under the Union or a state. 312. All India services. 315. Public Service Commissions for the Union and for the states. 320. Functions of Public Service Commission. 323A. Administrative Tribunals. 324. Superintendence, direction and control of election to be vested in Election Commission. 330. Reservation of seats for scheduled caste and scheduled tribe in the House of People. 335. Claim of scheduled caste and scheduled tribe to service and posts. 352. Proclamation of emergency, national emergency. 356. Provision in case of failure of constitutional machinery, instead President's rule. 360. Provision as to financial emergency. 365. Effect of failure to comply with or to give effect to direction given by the Union, President's rule. 368. Power of Parliament to amend the Constitution and procedure therefore. 370. Temporary provisions with respect to state of Jammu and Kashmir. Table 3.3. Schedules of the Constitution at a glance. First schedule. Name of the state and their territorial jurisdiction. 1 and 4. Second, name of the union territories and their extent. Second schedule. Provision relating to the emoluments, allowances, privileges and so on of 59, 65, 75, 97, 125, 148, 158, 164, 186 to 21. First, the President of India. Second, the Governor of State. Third, the Speaker and the Deputy Speaker of the Lok Sabha. 4. The Chairman and the Deputy Chairman of Rajya Sabha. 5. The Speaker and the Deputy Speaker of Legislative Assembly in the state. 6. The Chairman and Deputy Chairman of Legislative Council in the state. 7. The Judges of the Supreme Court. 8. The Judges of High Court. 9. The Comptroller and Auditor General of India. Third schedule. Forms of oath or affirmation for Article 75, 84, 99, 124, 146, 173, 188, 219. First, the Union Minister. Second, the candidates for election of the Parliament. Third, the Member of Parliament. Fourth, the Judge of the Supreme Court. 5. The Comptroller and Auditor General of India. 6. The State Ministers. 7. The candidates for election to the State Legislature. 8. The Member of the State Legislature. 9. The Judges of High Court. 4th. Allocation of seats in the Rajya Sabha to the states and the Union territories. 4 and 80. 5th. Provision relating to the administration and control of scheduled areas and scheduled tribes. 244. 6th schedule. Provision relating to the administration of tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram. 244 and 275. 7th schedule. Division of power between the Union and the state in terms of List 1 Union list, List 2 State list, List 3 Concurrent list. Presently the Union list contains 98 subject, originally 97. State list contains 59 subject, originally 66 and concurrent list contains 52 subject, originally 47. The Article 246. 8th schedule. Language recognized by the Constitution. Originally it had 14 languages but presently there are 22 languages. 344 and 351. They are Assamese, Bengali, Bodo, Dogri या डोंगरी, गुजराती, हिंदी, कन्नड़ा, कश्मीरी, कोंकणी, मैथिली या मैथिली, मलयालम, मणिपुरी, मराठी, नेपाली, ओडिया, पंजाबी, संस्कृत, संथाली, Sindhi, Tamil, Telugu and Urdu. Sindhi was added by 21st Amendment Act of 1967. Konkani, Manipur and Nepali were added by 71st Amendment Act of 1992. Bodo, Dongri, Maithili and Santhali were added by 92nd Amendment Act of 2003. Oriya was named as Odia by 96th Amendment Act of 2011. Ninth Schedule. Acts and Regulation originally 1331B are but presently 282 of the state's legislature dealing Ninth Schedule में Acts and Regulation originally 13 but presently 282 of the state's legislature dealing and with land reforms and abolition of Jamindari system and of the parliament dealings with other matters. This schedule was added by the First Amendment 1951 to protect the law included in it from judicial scrutiny on the ground of violation of fundamental rights. However, in 2007, the Supreme Court ruled that the laws included in this schedule after April 24, 1973 are now open to judicial review. ये 31B में है. 10th Schedule. Provision relating to disqualification of the member of parliament and state legislature on the ground of defection. This schedule was added by the 52nd Amendment Act of 1985, also known as Anti-Defection Law. ये है 102 and 191 में. Eleventh Schedule specifies the power, authority and responsibility of Panchayat. It has 29 matters. This schedule was added by 73rd Amendment Act of 1992. 243G. 12th Schedule specifies the power, authority and responsibility of municipalities. It has 18 matters. This schedule was added by 74th Amendment of 1992. 243W. Sources of the Constitution at a glance, Table 3.4. गवर्नमेंट ऑफ इंडिया एक्ट 1935, इससे लिया गया फेडरल स्कीम, ऑफिस ऑफ गवर्नर, जुडिशरी, पब्लिक सर्विस कमीशन, इमरजेंसी प्रोविजन एंड एडमिनिस्ट्रेटिव डिटेल्स. सेकंड आपका है ब्रिटिश कॉन्स्टिट्यूशन, पार्लियामेंट्री गवर्नमेंट, रूल ऑफ लॉ, लेजिस्लेटिव प्रोसीजर, सिंगल सिटीजनशिप, कैबिनेट सिस्टम, प्रेरोगेटिव रिट्स, पार्लियामेंट्री प्रिविलेजेस एंड बाइकैमरलिज्म. थर्ड आपका है यूएस कॉन्स्टिट्यूशन, फंडामेंटल राइट्स, independence of judiciary, judicial review, impeachment of the president, removal of Supreme Court and High Court judges and post of vice president. Fourth, Irish Constitution, DPSP, Directive Principle of State Policy, nomination of member of Rajya Sabha and method of election of president. 5. Canadian Constitution, federation with a strong centre, vesting with residuary power in the centre, appointment of state governors by the centre and the advisory jurisdiction of the Supreme Court. 6. Australian Constitution, concurrent list, freedom of trade, commerce and intercourse and joint sitting of two houses of parliament. 7. Weimar Constitution of Germany, suspension of fundamental right during emergency. 8. Soviet Union, USSR, now Russia, fundamental duties and the ideal of justice, social, economic and political in the preamble. 9. French Constitution, Republic and the ideals of liberty, equality and fraternity in the preamble. 10th. South African Constitution, procedure for amendment of the Constitution and election of member of Rajya Sabha. 11. Japanese Constitution, procedure established by law. Table 7.1, Fundamental Rights at a glance. Right to equality, Article 14 to 18. Equality before law and equal protection of law, Article 14. B. Prohibition and discrimination on ground of religion, race, caste, sex or place of birth, Article 15. C. Equality of opportunity in matter of public employment, Article 16. Abolition of untouchability and prohibition of its practice, Article 17. E. Abolition of titles except military and academic, Article 18. Second, right to freedom, Article 19 to 22. Protection of 6 rights regarding freedom of speech and expression, second assembly, third association, तो फाइटर प्लेन का साउंड इतना तेज रहता है. Second, right to freedom, Article 19 to 22. A. Protection of 6 rights regarding freedom of first, speech and expression. Second, assembly. Third, association. Fourth, movement. 5, residence. 6, profession. Article 19. B. Protection in respect of conviction of offence. Article 20. C. Protection of life and personal liberty. Article 21. D. Right to elementary education. Article 21A. E. Protection against arrest and detention in certain cases. Article 22. Third, right against exploitation. Article 23 and 24. A. Prohibition of traffic in human beings and forced labor. Article 23. B. Prohibition of employment of children in factories, etc. Article 24. Fourth, right to freedom of religion. Article 25 to 28. Freedom of conscience and free profession, practice and prorogation of religion. Article 25. B. Freedom to manage religious affairs. Article 26. C. Freedom for payment of taxes for promotion of any religion. Article 27. D. Freedom from attending religious instruction or worship in certain educational institution. Article 28. 5. Culture and educational right. Article 29 to 30. Protection of language, script and culture of minorities. Article 29. B. Right of minorities to establish and administer educational institution. Article 30. Right to constitutional remedies. Article 32. Right to move the Supreme Court for the enforcement of fundamental rights, including the writs of first, habeas corpus; second, mandamus; third, prohibition; fourth, certiorari; 5, quo warranto. Article 32. Fundamental rights of foreigners. Fundamental rights only to citizens and not to foreigners, and fundamental right available to both citizen and foreigner except enemy aliens. ये सिटीजन को है, फॉरेनर को नहीं है. यहाँ पे सिटीजन को भी है प्लस फॉरेनर्स को भी है. पहला, प्रोहिबिशन ऑफ डिस्क्रिमिनेशन ऑन ग्राउंड ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ. आर्टिकल 15 यहाँ पे है. यहाँ पर इक्वलिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉ. आर्टिकल 14 दोनों को है. ये इक्वलिटी ऑफ अपॉर्चुनिटी इन मैटर ऑफ पब्लिक एम्प्लॉयमेंट. आर्टिकल 16 है सी को खाली. यहाँ पे प्रोटेक्शन इन रिस्पेक्ट ऑफ कन्विक्शन फॉर ऑफेंस. आर्टिकल 20 सी प्लस एफ दोनों को है. थर्ड, प्रोटेक्शन ऑफ 6 राइट्स रिगार्डिंग फ्रीडम ऑफ स्पीच, एक्सप्रेशन, असेंबली, एसोसिएशन, मूवमेंट, रेसिडेंस एंड प्रोफेशन. 19 इसी को खाली है. यहाँ प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी. 21 दोनों को है. फोर्थ, प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी. 21 सी को है. फोर, राइट टू एलिमेंट्री एजुकेशन. आर्टिकल 21 ए दोनों के पास है. यहाँ पे राइट ऑफ माइनॉरिटीज़ टू इस्टेब्लिश एंड एडमिनिस्टर एजुकेशनल इंस्टीट्यूशन. आर्टिकल 30 है. यहाँ पर प्रोटेक्शन अगेंस्ट अरेस्ट एंड डिटेंशन इन सर्टेन केसेस. आर्टिकल 22 सी प्लस एफ दोनों के पास है. 6, प्रोहिबिशन ऑफ ट्रैफिक इन ह्यूमन बींग्स एंड फोर्स्ड लेबर. आर्टिकल 23 सी प्लस एफ दोनों के पास है. 7, प्रोहिबिशन ऑफ एम्प्लॉयमेंट ऑफ चिल्ड्रन इन फैक्ट्रीज एक्सेट्रा. आर्टिकल 24 दोनों के पास है. 8, फ्रीडम ऑफ कॉन्साइंस एंड फ्री प्रोफेशन, प्रैक्टिस एंड प्रोरोगेशन ऑफ रिलीजन. आर्टिकल 25 सी प्लस एफ दोनों के पास है. 9, फ्रीडम टू मैनेज रिलीजियस अफेयर्स. आर्टिकल 26 सी प्लस एफ दोनों के पास है. 10, फ्रीडम फॉर पेमेंट ऑफ टैक्सेस फॉर प्रमोशन ऑफ एनी रिलीजन. आर्टिकल 27 सी प्लस एफ दोनों के पास है. 11, फ्रीडम फॉर अटेंडिंग रिलीजियस इंस्ट्रक्शन और वर्शिप इन सर्टेन एजुकेशनल इंस्टीट्यूशन. आर्टिकल 28 सी प्लस एफ दोनों के पास है. एक बार हम वापस देखते हैं सी प्लस एफ के पास कौन कौन से आर्टिकल है. तो आर्टिकल 14, 20, 21, 21A, 22, 23, 24, 25, 26, 27 और 28 है. इसके बाद हम देखते हैं टेबल 7.3, मार्शल लॉ एंड वर्सेस नेशनल इमरजेंसी. तो मार्शल लॉ जो है उसमें इट अफेक्ट्स ओनली फंडामेंटल राइट. वहीं पे नेशनल इमरजेंसी जो है वो इट अफेक्ट्स नॉट ओनली फंडामेंटल राइट बट ऑल्सो सेंटर स्टेट रिलेशन, डिस्ट्रीब्यूशन ऑफ रेवेन्यूज एंड लेजिस्लेटिव पावर बिटवीन सेंटर एंड स्टेट एंड मे एक्सटेंड द टेन्योर ऑफ द पार्लियामेंट. मार्शल लॉ का सेकंड पॉइंट है, इट सस्पेंड द गवर्नमेंट एंड ऑर्डिनरी लॉ कोर्ट्स. नेशनल इमरजेंसी सेकंड, इट कंटिन्यूज द गवर्नमेंट एंड ऑर्डिनरी लॉ कोर्ट्स. मार्शल लॉ में थर्ड, इट इज इम्पोज ऑन टू रिस्टोर द ब्रेकडाउन ऑफ लॉ एंड ऑर्डर ड्यू टू एनी रीजन. National emergency, it can be imposed only on three grounds: war, external aggression, or armed rebellion. Martial law, it is imposed in specific area of the country. National emergency, it is imposed either in the whole country or in any part of it. 5. It has no specific provision in the constitution, it is implicit. यहाँ पे ये जो है it has national, it has specific and detailed provision in the constitution and it is explicit. अब हम देखते हैं टेबल 7.4. आर्टिकल्स रिलेटेड टू फंडामेंटल राइट्स एट अ ग्लांस. 12. डेफिनेशन ऑफ स्टेट. 13. लॉ इनकंसिस्टेंट विद और इन डेरोगेशन ऑफ द फंडामेंटल राइट. अब राइट टू इक्वालिटी में देखते हैं. 14. इक्वालिटी बिफोर लॉ. 15. प्रोहिबिशन ऑफ डिस्क्रिमिनेशन ऑन ग्राउंड ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ. 16. इक्वालिटी ऑफ अपॉर्चुनिटी इन मैटर ऑफ पब्लिक एम्प्लॉयमेंट. 17. एबॉलिशन ऑफ अनटचेबिलिटी. 18. एबॉलिशन ऑफ टाइटल्स. राइट टू फ्रीडम. 19. Protection of certain rights regarding freedom of speech, etc. 20. Protection in respect of conviction for offences. 21. Protection of life and personal liberty. 21A. Right to education. 22. Protection against arrest and detention in certain cases. Right against exploitation. 23rd. Prohibition of traffic in human beings and forced labor. 24. Prohibition of employment of children in factories, etc. Right to freedom of religion. 25. Freedom of conscience and free professional practice and propagation of religion. 26. Freedom to manage religious affairs. 27. Freedom as to payment of taxes for promotion of any particular religion. 28. Freedom as to attendance at religious instruction or religious worship in certain educational institution. Cultural and educational right. 29. Protection of interest of minorities. 30. Right of minorities to establish and administer educational institution. Right to property repealed. 31. Compulsory acquisition of property repealed. Saving of certain laws. 31A. Saving of laws providing for acquisition of estates, etc. 31B. Validation of certain acts and regulations. 31C. Saving of laws giving effect to certain directive. 31 directive principle. 31D. Saving of laws in respect of anti-national activities repealed. Right of constitutional remedies. 32. Remedies for enforcement of rights conferred by this part. 32A. Constitutional validity of the state's law not to be considered in proceeding. Article 32 repealed. 33. Power of Parliament to modify the rights conferred by this part in their application of to forces, etc. 34. Restriction on rights conferred by this part while martial law is in force in any area. 35. Legislation to give effect to the provision of this part. Table 8.1. Distinction between fundamental rights and DPSP. Fundamental rights or DPSP. Fundamental rights, these are negative as they prohibit the state from doing certain things. Directive principle, these are positive as they require the state to do certain things. Second, they fundamental right, they are justiciable, that is they are legally enforceable by courts in case of their violation. DPSP, these are non-justiciable, this is they are not legally enforceable by courts for their violation. Fundamental rights. Third, they aim at establishing political democracy in the country. DPSP, they aim at establishing social and economic democracy in the country. Fundamental rights. 4, these have legal sanctions. DPSP, these have moral and political sanctions. Fundamental rights. 5, they promote the welfare of the individual, hence they are personal and individualistic. DPSP, they promote the welfare of the community, hence they are societarian and socialist. Fundamental rights, they do not require any legislation for their Implementation. They are automatically enforced. DPSP. They require legislation for their implementation. They are not automatically enforced. FR. 7th. The court are bound to declare a law violative of any of the fundamental right as unconstitutional and invalid. DPSP. The court cannot declare a law violative of any of the DP directive principle as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. Table 8.2 Articles related to DPSP at glance. 36. Definition of state. 37. Application of the principles contained in this part. 38. States to secure a social order for the promotion of the welfare of the people. 39. Certain principles of policy to be followed by the state. 39A. Equal justice and free legal aid. 40. Organization of village panchayats. 41. Right to work, education and to public assistance in certain cases. 42. Provision for just and human condition of work and maternity relief. 43. Living wages etc. for workers. 43A. Participation of workers in management of industries. 43B. Promotion of cooperative societies. 44. Uniform civil code for citizens. 45. Provision for early childhood care and education for to children below age of 6 years. 46. Promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker sections. 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. 48. Organization of agriculture and animal husbandry. 48A. Protection and improvement of environment and safeguarding of forest and wildlife. 49. Protection of monuments and places and objects of national importance. 50. Separation of judiciary from executive. 51. Promotion of international peace and security. Table 11.1 Evolution of the basic structure of the Constitution. First, Keshwanand Bharti case 1973, popularly known as Fundamental Rights case. Elements of the basic structure. First, supremacy of the Constitution. Second, separation of power between the legislature and the executive and the judiciary. Third, republic and democratic form of government. Fourth, secular character of the Constitution. 5. Federal character of the Constitution. 6. Sovereignty and unity of India. 7. Freedom and dignity of the individual. 8. Mandate to build a welfare state. 9. Parliamentary system. Second, Indira Nehru Gandhi case 1975, popularly known as election case. First, India as a sovereign democratic republic. Second, equality of status and opportunity of an individual. Third, secularism and freedom of conscience and religion. Fourth, government of laws and not of men, that is rule of law. 5. Judicial review. 6. Free and fair election, which is implied in democracy. Third, Minerva Mills case 1980. First, limited power of parliament to amend the constitution. Second, judicial review. Third, harmony and balance between fundamental rights and DPSP. Fourth, Central Coalfields case limited case 1980. Effective access to justice. 5. Bhim Singh Ji case 1981. Welfare state socio-economic justice. 6. SP Sampath Kumar case 1987. First, rule of law. Second, judicial review. 7. P. Samburathi case 1987. Rule of law and judicial review. 8. Delhi Judicial Service Association case 1991. Power of the Supreme Court under Article 32, 136, 141 and 142. 9. Indira Sahni case 1992, popularly known as Mandal case. Rule of law. 10. Kumar Padma Prasad case 1992, independence of judiciary. 11. Kyoto Hollan case 1993, popularly known as defection case. Free and fair election. Second, sovereignty, democratic and republic structure. 12. Raghunath Rao case 1993, Paila principle of equality. Second, unity and integrity of India. Third, Sorry, 13 SR Bombay case 1994, first federalism, second secularism, third democracy, fourth unity and integrity of the nation, five social justice, and six judicial review. 14 L. Chandra Kumar case 1997, a power of the High Court under Article 226 and 227. 15 Indira Sahni, second case 2000, principle of equality. 16 All India Judges Association case 2002, independent judicial system. 17 Kuldeep Nayar's case 2006, democracy and free and fair election. 18 M. Nagaraja case 2006, principle of equality. 19 IR Koilo case 2007, popularly known as 9 schedule case. First, rule of law. Second, separation of power. Third, principle or essence of underlying fundamental rights. Fourth, judicial review. 5, principle of equality. 20 Ram Jethmalani case 2011, power of Supreme Court under Article 32. 21 Namit Sharma case 2013, freedom and dignity of the individual. 22 Madras Bar Association case 2014, first judicial review. Second, power of the High Court under Article 226 and 227. Table 20.1, comparing parliamentary and presidential system. पार्लियामेंट्री एंड प्रेसिडेंशियल फीचर. पहले पार्लियामेंट्री देखते हैं, दोनों देखते हैं. पार्लियामेंट्री ड्यूअल एग्जीक्यूटिव, प्रेसिडेंशियल सिंगल एग्जीक्यूटिव. पार्लियामेंट्री मेजॉरिटी पार्टी रूल, प्रेसिडेंशियल प्रेसिडेंट एंड लेजिस्लेटर इलेक्टेड सेपरेटली फॉर अ फिक्स टर्म. पार्लियामेंट्री कलेक्टिव रिस्पॉन्सिबिलिटी, प्रेसिडेंशियल नॉन रिस्पॉन्सिबिलिटी. पार्लियामेंट्री पॉलिटिकल होमोजेनिटी, प्रेसिडेंशियल पॉलिटिकल होमोजेनिटी may not exist. Parliamentary double membership, presidential single membership. Parliamentary leadership of Prime Minister, presidential domination of President. Parliamentary dissolution of Lower House, presidential no dissolution of Lower House. Parliamentary fusion of power, presidential separation of powers. Parliamentary merits, harmony between legislature and executive. Presidential demerits, conflict between legislature and executive. Parliamentary merits, responsible government. Presidential non-responsible government. Parliamentary prevent despotism. Presidential may lead to autocracy. Parliament wide representation. Presidential narrow representation. Demerits, unstable government. Merits, stable government. Demerits, no continuity policy. Merits, definiteness in policies based on separation of power and government by experts. Demerits, against separation of powers and governments by amateurs. अगेंस्ट सेपरेशन ऑफ पावर हो गया ये. टेबल 13.1, कंपेयरिंग फीचर्स ऑफ फेडरल एंड यूनिटरी गवर्नमेंट. फेडरल गवर्नमेंट एंड यूनिटरी गवर्नमेंट. फेडरल गवर्नमेंट ड्यूअल गवर्नमेंट, दैट इज नेशनल गवर्नमेंट and regional government. Unitary government, single government, that is national government which may create regional governments. Federal, written constitution. Unitary constitution may be written France or unwritten Britain. Federal, division of power between the national and regional government. Unitary government, no division of power, all power are vested in the national government. Federal, supremacy of the constitution. Unitary, constitution may be supreme Japan or may not be supreme Britain. Federal, rigid constitution. Unitary, constitution may be rigid France and flexible Britain. Federal, independent judiciary. Unitary, judiciary may be independent or may not be independent. Federal, bicameral legislature. Unitary, legislature may be bicameral Britain and unicameral China. Table 15.2, Zonal Council at a glance. Northern Zonal Council, Himachal Pradesh, Haryana, Punjab, Rajasthan, Delhi, Chandigarh, Jammu and Kashmir and Ladakh. New Delhi headquarter. Second, Central Zonal Council, UP, Uttarakhand, Chhattisgarh, MP, Allahabad headquarter. Third, Eastern Zonal Council, Bihar, Jharkhand, West Bengal, Odisha headquarter Kolkata. Western Zonal Council, Gujarat, Maharashtra, Goa, Dadar and Nagar Haveli, Daman and Diu headquarter Mumbai. 5. Southern Zonal Council, Andhra Pradesh, Telangana, Karnataka, Tamil Nadu, Kerala and Puducherry headquarter Chennai. Table 15.3 Articles related to interstate relation at a glance. Mutual recognition of public acts, etc. Article 261 Public acts record and public and judicial proceedings. Dispute relating to waters. Article 262 Adjudication of dispute relating to water of interstate river or river valleys. Coordination between states. Article 263 Provision with respect to interstate council. Interstate trade and commerce. Article 301 Freedom of trade, commerce and intercourse. 302 Freedom of parliament to impose restriction on trade, commerce and intercourse. 303 Restriction on the legislative power of the union and of the state with regard to trade and commerce. 304 Restriction on trade, commerce and intercourse among states. 305 Saving of existing laws and laws providing for state monopolies. 306 Power of certain states in Part B of the first schedule to impose restriction on trade and commerce repealed. 307 Appointment of authority for carrying out the purpose of Article 301 to 304. Table 15.3. Table 20.1 Distinction between Council of Ministers and Cabinet. Council of Ministers, it is a wider body consisting of 60 to 70 members. Cabinet, it is smaller body consisting of 15 to 20 ministers. Council of Ministers, it includes all three categories of ministers, that is Cabinet Minister, Minister of State and Deputy Minister. Cabinet, it includes Cabinet Ministers only. It is a part of the Council of Ministers. Council of Ministers, it does not meet as a body to transact government business. It has no collective functions. Cabinet, it meets as a body frequently and usually once in a week to deliberate and take decision regarding the transaction of government business. Thus, it has collective functions. Council of Ministers and Cabinet. It is vested with all powers, but in theory. It exercises in practice the power of Council of Ministers and thus acts for the latter. Its functions are determined by the Cabinet. It directs the Council of Ministers by taking policy decisions which are binding on all ministers. It implements the decision taken by the Cabinet. It supervises the implementation of its decision by the Council of Ministers. It is a constitutional body dealt in details by the Article 74 and 75 of the Constitution. Its size and classification are, however, not mentioned in the Constitution. Its size is determined by the Prime Minister according to the exigence of the time requirement of the situation. Its classification into three-tier bodies based on convention of parliamentary government as developed in Britain. It has, however, got a legislative sanction. Thus, the Salaries and Allowances Act of 1952 defines a minister as a member of the Council of Ministers by whatever name called and includes a deputy minister. कैब में देख लेते हैं अब. It is inserted in Article 352 of the Constitution in 1978. by the 44th Constitutional Amendment Act. Thus, it did not find a place in the original text of the Constitution. Now, also, Article 352 only defines the Cabinet, saying that it is the Council consisting of the Prime Minister and other ministers of the Cabinet rank, appointed under Article 75, and does not describe its power and functions. In other words, its role in our political administrative system is based on the Convention of Parliamentary Government as developed in Britain. 8. It is collectively responsible to the lower house of the Parliament, CAB. It enforces the collective responsibility of the Council of Ministers to the lower house of Parliament. Table 22.1 Adjournment versus prorogation. Adjournment. It only terminates a sitting and not a session of the House. Prorogation. It not only terminates a sitting but also a session of the House. Adjournment. It is done by presiding officer of the House. Prorogation. It is done by the President of India. Adjournment. It does not affect the bills or any other business pending before the House, and the same can be resumed when the House meets again. Prorogation. It also does not affect the bills or any other business pending before the House. However, all pending notices other than those for introducing bills lapse on prorogation, and fresh notice have to be given for the next session. In Britain, prorogation brings to an end all bills or any other business pending before the House. Table 22.2 Censor motion versus no confidence motion. Censor motion, it should state the reason for its adoption in the Lok Sabha. No confidence motion, it needs not state the reason for its adoption in the Lok Sabha. Censor motion, it can be moved against an individual minister or a group of ministers or the entire council of ministers. No confidence motion, it can be moved against the entire council of ministers only. Censor motion, it is moved by censoring the council of ministers for specific policies and action. No confidence motion, it is moved for asserting the confidence of Lok Sabha in the council of ministers. Censor motion, if it is passed in the Lok Sabha, the council of ministers need not resign from the office. No confidence motion, if it is passed in the Lok Sabha, the council of ministers must resign from office. Table 22.9 Article related to Parliament at glance. General. 79 Constitution of Parliament. 80 Composition of the Council of State. 81 Composition of the House of the People. 82 Readjustment after each census. 83 Duration of House of Parliament. 84 Qualification for membership of Parliament. 85 Sessions of Parliament, prorogation and dissolution. 86 Right of President to address and send message to Houses. 87 Special address by the President. 88 Right of Ministers and Attorney General as respects House. Officers of Parliament. 89 The Chairman and Deputy Chairman of the Council of States. 90 Vacation and resignation and removal of office of Deputy Chairman. 91 Power of the Deputy Chairman or other person to perform the duties of the office or to act as Chairman. 92 The Chairman and the Deputy Chairman not to preside while a resolution for his removal from office is under consideration. 93 The Speaker and Deputy Speaker of the House of the People. 94 Vacation and resignation of and removal from the office of Speaker and Deputy Speaker. 95 Power of the Deputy Speaker and other to perform the duties of the office or to act as Speaker. 96 The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. 97 Salaries and allowances of the Chairman and Deputy Chairman and the Speaker and the Deputy Speaker. 98 Secretariat of Parliament, conduct of businesses. 99 Oath and affirmation by members. 100 Voting in houses, power of houses to act notwithstanding vacancies and quorum. Disqualification of members. 101 Vacation of seats. 102 Disqualification for membership. 103 Decision on questions as to disqualification of members. 104 Penalty for sitting and voting before making oath or affirmation under Article 99 or when not qualified or when disqualified. Powers, privileges, immunities of Parliament and its members. 105. Powers, privileges, etc. of the House of Parliament and the member and committees thereof. 106. Salaries and allowances of members. Legislative procedure. 107. Provision as to introduction and passing of bills. 108. Joint sitting of both houses in certain cases. 109. Special procedure in respect of money bills. 110. Definitions of money bill. 111. Assent to bills. Procedures in financial matters. 112. Annual financial statement. 113. Procedure in Parliament with respect to estimates. 114. Appropriation bills. 115. Supplementary, additional and or excess grants. 116. Votes on account, vote of credit, exceptional grants. 117. Special provision as to financial bills. Procedure generally. 118. Rules of procedure. 119. Regulation by law of procedure in Parliament in relation to financial business. 120. Language to be used in Parliament. 121. Restriction on discussion in Parliament. 122. Courts not to inquire into proceeding of Parliament. Legislative powers of the President. 123. Power of the President to promulgate ordinances during recess of Parliament. Table 26.1. Comparison Indian and American Supreme Court. Indian Supreme Court. Its original jurisdiction is confined to federal cases. American Supreme Court original jurisdiction covers not only federal cases but also relating to naval forces, maritime activities, ambassadors, etc. Second, Indian. Its appellate jurisdiction covers constitutional, civil and criminal cases. American. Its appellate jurisdiction is confined to constitutional cases only. Indian. It has a very wide discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal except military. American. It has no such plenary power. Indian. It has advisory jurisdiction. American. Has no advisory jurisdiction. Indian. Its scope of judicial review is limited. American. Scope of judicial review is very wide. Indian. It defends rights of the citizen according to a procedure established by law. American. It defends right of the citizen according to the due process of law. Indian. Its jurisdiction and powers can be enlarged by Parliament. American. Its jurisdiction and powers are limited to that conferred by the Constitution. Indian. It has the power of judicial superintendence and control over state high court due to integrated judicial system. American. It has no such power due to double or separated judicial system. Article 26.2. Table 26.2 article related to Supreme Court at a glance. Article 124 Establishment and Constitution of Supreme Court. 124A NGAC National Judicial Appointment Commission. 124B Functions of Commission. 124C Power of Parliament to make law. 125 Salaries etc. of judges. 126 Appointment of Acting Chief Justice. 127 Appointment of ad hoc judges. 128 Attendance of retired judges at sitting of the Supreme Court. 129 Supreme Court to be a court of record. 130 Seats of Supreme Court. 131 Original jurisdiction of the Supreme Court. 131A Exclusive jurisdiction of the Supreme Court in regard to questions as to constitutional validity of central laws repealed. 132 Appellate jurisdiction of Supreme Court in appeals from High Court in certain cases. 133 Appellate jurisdiction of Supreme Court in appeals from High Court in regard to civil matters. 134 Appellate jurisdiction of Supreme Court in regard to criminal matters. 134A Certificate for appeal to the Supreme Court. 135 Jurisdiction and powers of the Federal Court under existing law to be exercisable by Supreme Court. 136 Special leave to appeal by the Supreme Court. 137 Review of judgment or order by the Supreme Court. 138 Enlargement of the jurisdiction of the Supreme Court. 139 Conferment of the Supreme Court of power to issue certain writs. 139A Transfer of certain cases. 140 Ancillary power of Supreme Court. 141 Laws declared by Supreme Court to be binding on all courts. 142 Enforcement of decrees and order of Supreme Court and orders as to discovery etc. 143 Power of President to consult Supreme Court. 144 Civil and judicial authorities to act in the aid of Supreme Court. 144A Special provision as to disposal of questions relating to constitutional validity of laws repealed. 145 Rules of court, etc. 146 Officers and servants and the expenses of the Supreme Court. 147 Interpretation. Table 27.1 Number of acts and regulations included in 9th schedule. First, included before April 24, 1973. First Amendment 1951 13. Number of acts and regulations included in 9th schedule 13 1 to 13. Fourth Amendment 1955 7 14 to 20. Seventh Amendment 1964 44 21 to 64. 29th Amendment 1972 2 65 and 66. Included after 24 April 1973. 34th Amendment 1974 20 67 to 86. 39th Amendment 1975 38 87 to 124. 40th Amendment 1976 64 125 to 188. 47th Amendment 1984 14 189 to 202. 66th Amendment 1990 55 203 to 257. 76th Amendment 1994 first 1 275A. 78th Amendment 1995 27 258 to 284. Table 30.1 Comparing veto power of President and Governor. President with regard to ordinary bill. Governor with regard to ordinary bill. President, every ordinary bill after it is passed by both the House of Parliament either singly or a joint sitting is presented to the President for his assent. He has three alternatives. He may give his assent to the bill. The bill then becomes an act. Second, he may withhold his assent to the bill. The bill then ends and does not become an act. Third, he may return the bill for reconsideration of the House. If the bill is passed by both the House again with or without amendment and presented to the President for his assent, the President must give his assent to the bill. Thus, the President enjoys only a suspensive veto. Governor. Ordinary bill. Every ordinary bill after it is passed by the Legislative Assembly in case of a unicameral legislature or by both the House in case of bicameral legislature, either in the first instance or in the second instance, is presented to the Governor for his assent. He has four alternatives. First, he may give his assent to the bill. The bill then becomes the act. Second, he may withhold his assent to the bill. The bill then ends and does not become an act. Third, he may return the bill for reconsideration of the House or Houses. If the bill is passed by the House or Houses again with or without amendment and presented to the Governor for his assent, the Governor must give his assent to the bill. Thus, the Governor enjoys only a suspensive veto. Fourth, he may reserve the bill for the consideration of the President. When a state bill is reserved by the Governor for the consideration of the President has three alternatives. He may give his assent to the bill then becomes an act. He may withhold his assent to the bill then ends and does not become an act. Third, he may return the bill for reconsideration of the House or Houses of the state legislature. When a bill is so returned, the House or Houses have to reconsider it within 6 months. If the bill is passed by the House or Houses again or withhold amendment and presented to the President for his assent, the President is not bound to give his assent to the bill. He may give his assent to such a bill or withhold his assent. When the Governor reserves a bill for the consideration of the President, he will not have any further role in the enactment of the bill. If the bill is returned by the President for the reconsideration of the House or Houses and is passed again, the bill must be presented again to the presidential assent only. If the President gives his assent to the bill, it becomes an act. This means that the assent of the Governor is no longer required. Every money bill, after it is passed by the Parliament, is presented to the President for his assent. He has two alternatives. He may give his assent to the bill and the bill then becomes an act. He may withhold his assent to the bill and the bill then ends and does not become an act. Every money bill, after it is passed by the state legislature, unicameral or bicameral, is presented to the governor for his assent. He has three alternatives. First, he may give his assent to the bill, then the bill becomes an act. Second, he may withhold his assent to the bill then ends and does not become an act. Third, he may reserve the bill for the consideration of the president. Thus, the president cannot return the money bill for the reconsideration of the parliament. Normally, the president gives his assent to a money bill as it is introduced in the parliament with his previous permission. When a money bill is reserved for the governor for the consideration of the president has two alternatives. A. He may give his assent to the bill then becomes an act. B. He may withhold his assent to the bill then ends and does not become an act. Thus, the president cannot return a money bill for reconsideration of the state legislature, as in the case of the parliament. Governor. Thus, the governor cannot return a money bill for the reconsideration of the state legislature. Normally, the governor gives his assent to a money bill as it is introduced in the state legislature with his previous permission. When the governor reserves a money bill for the consideration of the president, he will not have any further role in the enactment of the bill. If the president gives his assent to the bill, it becomes an act. This means that the assent of the governor is no longer required. Table 30.2. Comparing ordinance making power of president and governor. President. He can promulgate an ordinance only when both the House of Parliament are not in session or when either of the two House of Parliament is not in session. The second provision implies that an ordinance can also be promulgated by the president when only one house is in session, because a law can be passed by both the houses and not by one house alone. Ordinance governor. He can promulgate an ordinance only when the legislative assembly, in case of unicameral legislature, is not in session, or in case of bicameral legislature, when both the house of the state legislature are not in session, or when either of the house of the state legislature is not in the session. The last provision implies that an ordinance can be promulgated by the governor when only one house in the house of bicameral legislature is in session, because a law can be passed by both the house and not by one house alone. President. He can promulgate an ordinance only when he is satisfied that President. He can promulgate an ordinance only when he is satisfied that circumstances exist which render it necessary for him to take immediate action. Governor. He can promulgate an ordinance only when he is satisfied that circumstances exist which render it necessary for him to take immediate action. President. His ordinance making power is extensive with the legislative power of the parliament. This means that he can issue ordinance only on those subjects on which the parliament can make laws. Governor. His ordinance making power is coextensive with the legislative power of the state legislature. This means that he can issue ordinances only on those subjects on which the state legislature can make laws. President. An ordinance issued by him has the same force and effect as an act of parliament. Governor. An ordinance issued by him has the same force and effect as an act of the state legislature. President. An ordinance issued by him is subject to the same limitation as an act of parliament. This means that an ordinance issued by him will be invalid to the extent it make any provision which the parliament cannot make. Governor. An ordinance issued by him is subject to the same limitation as an act of the state legislature. This means that an ordinance issued by him will be invalid to the extent it makes any provision which the state legislature cannot make. President. He can withdraw any ordinance at any time. Governor, he can withdraw an ordinance at any time. President, his ordinance making power is not discretionary power. This means that he can promulgate or withdraw any ordinance only on the advice of the Council of Ministers, headed by the Prime Minister. Governor, his ordinance making power is not discretionary power. This means that he can promulgate or withdraw any ordinance only on the advice of council headed by Chief Minister. Okay? Advice of the council headed by Chief Minister. President, an ordinance issued by him should be laid before both the houses of parliament when it reassembles. Governor, an ordinance issued by him should be laid before the legislative assembly of both the houses of the state legislature in case of bicameral legislature when it reassembles. President, an ordinance issued by him ceased to operate on the expiry of 6 weeks from the reassembly of the Parliament. It may cease to operate even earlier than the prescribed 6 weeks if both the House of the Parliament passes a resolution disapproving it. Governor, an ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of the state legislature. It may cease to operate even earlier than the prescribed 6 weeks if a resolution disapproving it is passed by the Legislative Assembly and is agreed to by the Legislative Council in case of bicameral legislature. President, he needs no instruction for making an ordinance. Governor, he cannot make an ordinance without the instruction from the President in three cases. First, if a bill containing the same provision would have required the previous sanctions of the President for its introduction in the state legislature. Second, if he would have deemed it necessary to reserve a bill containing the same provision for the consideration of the President. Third, if an act of the state legislature containing the same provision would have been invalid without receiving the President's assent. Table 30.3 comparing pardoning power of President and Governor. President, he can pardon, reprieve, respite, remit, suspend, or commute the punishment or sentence of any person convicted of any offence against central law. Governor, he can pardon, reprieve, respite, remit, suspend, or commute the punishment of or sentence of any person convicted of any offence against a state law. POI. He can pardon, reprieve, respite, remit, suspend, or commute a death sentence. He is the only authority to pardon a death sentence. Governor, he cannot pardon a death sentence even if a state law prescribes for death sentence. The power to grant pardon lies with the President and not the Governor, but the Governor can suspend, remit, or commute a death sentence. POI. He can grant pardon, reprieve, respite, remission, suspension, remission, or commutation in respect to punishment or sentence by a court martial, military law. Governor, he does not possess any such power. .4 Articles related to Governor at a glance. Article 153 Governors of State, 154 Executive Power of State, 155 Appointment of Governor, 156 Terms of Office of Governor, 157 Qualification for Appointment of as Governor, 158 Conditions of Governor's Office, 159 Oath or Affirmation by the Governor, 160 Discharge or the function of the Governor in certain contingencies, 161 Power of the Governor to grant pardons and others, 162 Extent of executive power of state, 163 Council of Ministers to aid and advise the Governor, 164 Other provision as to ministers like appointment, terms, salaries and others, 165 Advocate General for the state, 166 Conduct of business of the government of state, 167 Duties of CM regarding furnishing of information to the Governor and so on, 174 Sessions of the state legislature prorogation and dissolution, 175 Right of the governor to address and send messages to the house or houses of state legislature. 176. Special address by the governor. 200. Assent to bills, that is assent of the governor of the bill passed by the state legislature. 201. Bills reserved by the governor for consideration of the president. 123. Power of governor to promulgate ordinances. 217. Governor being consulted by the president in matter of the appointment of the judges of High Court. 123. Appointment of district judges by the governor. 234. Appointment of persons other than district judges to the judicial service of the state by the governor. Table 38.2. Articles related to panchayats at a glance. Article 243 Definition. 243A Gram Sabha. 243B Constitutions of the Panchayat. 243C Composition of Panchayat. 243D Reservation of seats. 243E Duration of Panchayats and so on. 243F Disqualification of membership. 243G Power and authority and responsibility of Panchayat. 243H Power to impose taxes by and funds of the Panchayats. 243I Constitution of Finance Commission to review financial position. 243J Audit of accounts of Panchayats. 243K Elections to the Panchayats. 243L Application to Union Territories. 243M Part not to apply to certain cases. Part not to apply to certain areas. 243M. 243N Continuance of existing laws and Panchayats. 243O Bar to interference by courts in electoral matters. Table 38.3 Name of Panchayati Raj Institution in States 2019. आंध्र प्रदेश में ग्राम पंचायत मंडल परिषद जिला परिषद. अरुणाचल प्रदेश में ग्राम पंचायत आंचल समिति और जिला परिषद. असम में गांव पंचायत एंकैलिक पंचायत एंड जिला परिषद. बिहार में विलेज पंचायत पंचायत समिति और जिला परिषद. छत्तीसगढ़ में ग्राम पंचायत जनपद पंचायत और जिला पंचायत. गोवा विलेज पंचायत एंड जिला पंचायत. गुजरात विलेज पंचायत तालुका पंचायत डिस्ट्रिक्ट पंचायत. हरियाणा ग्राम पंचायत पंचायत समिति जिला परिषद. हिमाचल प्रदेश ग्राम पंचायत पंचायत समिति जिला परिषद. झारखंड ग्राम पंचायत पंचायत समिति जिला परिषद. ओके. उत्तर प्रदेश ग्राम पंचायत क्षेत्रीय पंचायत जिला परिषद. तेलंगाना ग्राम पंचायत मंडल परिषद जिला परिषद. उत्तराखंड ग्राम पंचायत इंटरमीडिएट पंचायत एंड डिस्ट्रिक्ट पंचायत. वेस्ट बंगाल ग्राम पंचायत पंचायत समिति एंड जिला परिषद. Table 38.4 Milestone in the evolution of Panchayati Raj towards first generation of Panchayat. 1948 to 49 Constituent Assembly debates on the role of Panchayati Raj in Indian polity. 1950 The Constitution of India comes into force on 26 January. Directive Principles of State Policy mentions Village Panchayat as unit of self-government. Article 40. 1952 Community Development Program starts on 2nd October. 1957 Balwant Rai Mehta Committee appointed in January submit its report on 24th November. 1958 to 60 Several state governments enact new Panchayat Acts bringing in three-tier Panchayati system. 1959 Jawaharlal Nehru inaugurates first generation Panchayats. At Nagaur in Rajasthan on 2nd October, Kerala District Council Bill is introduced in Kerala Assembly. Lapses after Assembly is dissolved. 1964 to 77 Decline of first generation Panchayati Raj institution. Second, growth and decline of second generation Panchayats. 1978 Panchayat elections are held in West Bengal on partly basis on 4th June, marking the beginning of second generation of Panchayati Raj. Ashok Mehta Committee on Working of Panchayats appointed on 12 December 1977 submit its report on 21st August. 1983 Karnataka government enacts new PR Act. 1984 Hanumanta Rao Committee on District Level Planning appointed by Planning Commission in September 1982 submits its report in May. 1985 Karnataka PR Act receives President's assent in July, comes into force on 14th August. 1985 GVK Rao Committee on Administrative Aspects of Rural Development, appointed by Planning Commission on 25th March, submit its report in December. 1986, Andhra Pradesh follows West Bengal and Karnataka Panchayati Raj model. 1987, Karnataka holds Panchayati election in January. 1992, Panchayats are dissolved and brought under administration in Karnataka. Third, Constitutionalization of Panchayati Raj. 1986, LM Singhvi Committee submit its report on 27th November, recommends constitutional status to Panchayats. 1988, Consultative Committees of Parliament appoints a subcommittee under chairmanship of P.K. Thangon to consider constitutional amendment. 1989, 64th Constitutional Amendment Bill is introduced in Parliament on 15th May, is defeated in Rajya Sabha on 15th October. 1990, 74th Constitutional Amendment Bill is introduced in Parliament on 7th September, lapses on dissolution of Lok Sabha. 1991, 72nd Panchayats and 73rd Municipalities Amendment Bill are introduced in Parliament, referred to the Parliament Joint Select Committee in September. 1992, Lok Sabha passes both the bills on 22nd December. Rajya Sabha passes them on 23rd December. 1993, 73rd Amendment Act 1992 comes into force on 24th April. 74th Amendment Act 1992 comes in force on 1st June. 1993 to 94, all state government pass conformity acts between 30 May 1993 to 23rd April 1994. 1994, Madhya Pradesh holds Panchayati election under 73rd Amendment dispensation on 30 May. 1996, provision of the Panchayats Extension of Scheduled Area Act 1996 PESA, extending 73rd Amendment Act to scheduled areas, comes into force on 24th December. Kerala launches People's Plan campaign on 16th August. 2001, Bihar holds Panchayat election after 23 years, 11 to 30 April. 2001, 83rd Constitutional Amendment Act 2000 amends Article 243M to dispense with reservation on for scheduled caste in Arunachal Pradesh, paving way for Panchayat election in the only state yet to hold them under the new dispensation. Table 38.5, Committees related to Panchayati Raj after constitutionalization. First, Task Force on Devolution of Power and Functions of Panchayati Raj Institution. Lalit Mathur, appointed 2001, reported 2001. Second, Expert Committee on Planning at the Grassroots Level. V. Ramachandram, 2005, report 2006. Task Force for Preparation of a Manual for District Planning. Srimati Rajwant Sandhu, 2008, report 2008. Fourth, Committee on Restructuring of DRDA, District Rural Development Authority. V. Ramchandran, 2010, report 2012. Expert Committee on Leveraging Panchayats for Efficient Delivery of Public Goods and Service. Mani Shankar Iyer, 2012, report in 2013.